Boen versus State.
Good morning, Your Honors.
Oh, and I forgot one thing. We also say goodbye to our Deputy Marshal, our Chief Deputy Marshal, Mr. Pawlowski. This is his last day presiding as our Marshal in this court. And we thank Ted for the service that he's given us. I apologize for that.
Oh, no, thank you for your service.
Good day, Ross.
Yes. Thank you, Your Honors. May it please the court, counsel. I would like to split my time 15 minutes, 5 minutes. That's okay with Your Honor.
Got it.
My name is Bill Sansone, and I am here on behalf of Mr. Eric Boen. Just a very quick factual background about how we got to this place. Mr. Boen pled to initially 5 counts in circuit court, and he was negotiated plea that included the victim in the case. He was sentenced to 10 years of probation. He did have one first violation, and it was for a dirty urine screen. In the trial court reinstated Mr. Boen with some additional conditions. The second violation is the reason we are here today. Mr. Boen was arrested for possession of 0.1 grams of cocaine. He had paraphernalia, and initially this all stemmed from a battery which the state no-filed prior to the VOP sentencing. Mr. Boen and his trial counsel, it was not trial counsel, pled open at the VOP, and the court sentenced Mr. Boen to 15.5 years in Florida State Prison for the violations, which was the 0.1 grams of cocaine and the paraphernalia. 2 issues before the court. I've withdrawn the third issue based on the state's answer brief. I realize this court did not have jurisdiction to review a motion for reconsideration. The first issue is that the state actually has the burden of establishing that the trial court at the VOP sentencing did not consider, at least in part, uncharged conduct in fashioning its 15.5-year sentence.
Can I ask
Yes.
you a question about that? In the plea form, your client admitted that he violated the conditions of his probation, right?
Yes,
In the
Your
plea form. And he acknowledged in that plea form that he can be resentenced effectively to the maximum, which I believe was like. Am I correct?
Yes.
Okay. And so and then the trial court sentence not it's sentenced close to the bottom of the guidelines.
Correct.
They reviewed downward departure, but got close to the guidelines. And so my question to you is, how do we look at this in a way that doesn't suggest the trial court would have revoked his probation and imposed the same sentence no matter what?
Well, I think that I understand Your Honor's question. I think it ties into issue 2, which is he had a motion for downward departure before him. And the issue in issue number 2 is that the trial court did not specifically go through the 2-step process that this court has specifically said a court must go through in order to facilitate appellate review, which is 1, whether the court has the legal authority to depart, and then 2, whether it should depart. Because
Is there any dispute that there were grounds to depart? There's drug use is involved, that's part of the reason for down departure.
is there, I'm sorry, Your
Is there
Honor.
any dispute that there was a reason to depart and the trial court decided to depart? There's drug use involved, is that one of the reasons for departure, or is that qualified?
Drug use does not, Your Honor. However, why it is unclear is defense counsel at the sentencing hearing put in defense exhibit 1. And defense exhibit 1 had lots of mental health issues that Mr. Boen was suffering from, PTSD.
Okay, so that isn't grounds to depart, mental health, independent of drugs.
Correct.
That's
Yeah, I was really confused by the briefing on this. There was, because I thought it said the defense counsel did not offer evidence regarding mental health.
Well, that in part, Your Honor, you're correct. He did not stress mental health at his sentencing. He did say Mr. Boen shouldn't go to Centerstone because that's not a dual diagnosis program.
Isn't the way that the mental health materials that are the exhibit and whatnot, didn't, the first appearance of all that was the attachment to the motion to reconsider, am I right? Because at the sentencing hearing, in reading that transcript, I didn't see any exhibits coming in on mental health.
There was the trial court put in Defense Exhibit 1, which contained in the, I don't know why in the record before this court, those pages were redacted.
Oh.
That's what trial counsel was referring to, albeit briefly, which was different types of assessments he had
He
had.
was talking about different facilities that could serve part of the probationary term. And
Right.
Phoenix House, Cornerstone, and the third place, right?
And I agree with Your Honor that it wasn't specifically argued to mental health, but trial counsels did say, we do not think Centerstone, I believe, is appropriate. Phoenix House is because it's a dual diagnosis program. And
Isn't that asking the trial court to read between the lines? I mean, I don't know if you were trial counsel.
I was not, Your Honor.
Okay, when reading this, my thought is, isn't there a counsel problem here as opposed to a trial court problem? And I don't mean to put you on the spot, but that's the impression that it leaves me with.
I do understand that, and I agree that the record by trial counsel, especially when you're putting forth a motion for downward departure in substance abuse in and of itself is not a reason, might not have been clear enough. However, Judge Reba, and if I could just jump to issue 2 real quick, Your Honor.
Yeah, please.
Yeah, Judge Reba stated when he was right before he imposed sentence, because he did acknowledge that there was a motion.
I don't see there's a reason.
He said, I don't see there's a reason, but then he did say this, like, quote, I just can't see a reason for me to depart. I don't see under both the regular departure statute. I suppose I should put that on the record to make sure everybody knows that I looked at it, which is 9.921.002, and under the violent felon offense of special concern, which is 948.06. I just, at this point in time, I don't see a reason to depart, and I'm not going to. The problem with that is it is unclear.
No, I do see the problem with
And
that.
part of it is, I understand trial counsel, and I understand Your Honor's question about asking the trial court to read between the lines. But my position is when the trial court specifically says 9.20026, he knows that that's before him.
Right.
So it's unclear whether Judge Reba is saying, you haven't met step 1.
Or there's no, one of the statutory reasons is not.
Exactly. You haven't met step 1, Mr. Bogen. So that's part of the reason. I don't see a reason to depart. I don't see a legal reason. I don't see a factual reason. Judge Reba did not delineate.
Was there a rehearing file? Did you file a motion for rehearing? Say, Judge, it's not clear whether there's a reason or not.
I can't remember.
Here's the reason I answer that. The trial judgment comes clothed with a presumption of correctness.
Right.
So the judge didn't follow it quite right. It's clothed with a presumption of correctness. So we have to stay with that presumption unless you follow the motion for rehearing. The judge said, you know what? I don't believe there's a ground for departure no matter what. Then we might be able to talk better.
I personally did not file a motion for rehearing. At the time I came in, I did file a motion for reconsideration and a motion for downward
Let
departure.
me ask you what I think might be a follow-on to Judge Valante's question. It seems to me that the law is that where the trial court exercises discretion not to downward depart, we got a body of case law that says any error in the step 1 analysis is harmless beyond a reasonable doubt. How does that affect your argument?
Well, Your Honor, and I will bring up a case that the state cited, which I think is directly on point with what Your Honor just said, is Geske versus State, which is 378 Southern 3rd, 1199, and that's second DCA of 2024. That's exactly what happened in that case, where this court did say that if it's clear from the record that the judge wasn't going to depart under step 2, an error in analysis on step one is harmless. However, this is what the trial court said in Geske. Quote, even if a threshold was met beyond a reasonable doubt or by clear and convincing evidence, or, beyond any reasonable doubt whatsoever, the court does not find it appropriate to depart under the circumstances to grant a downward departure in this case. So the facts in that case, the judge was clearly where the judge says, even if there was a threshold, that even if the threshold was met, she's referring to step one. She essentially said, it was Judge Padar, I was actually trial counsel in Geske. Under step one, whether he met that or not by any standard, I'm not going to depart under step two. And I believe this court said, even though she might not have gone through the proper analysis under step one, it is very clear under the record she was going to deny it under step two. Our position is part of it because of the way the record was developed and presented. It is unclear when Judge Reba says, I don't see a reason to depart, where he did have mental health issues.
Thanks for the question. I understand your argument. It's a very good argument, by the way. But your question implies that if the judge found a reason to depart and chose not to depart, that we wouldn't be here. But because the judge didn't clearly say there's no reason to depart, that's why we're here, correct?
Correct, Your Honor. I believe it's because it is unclear from the record whether.
But if it went back, let's say I'm very sympathetic to the argument. I used to be a trial judge. They heard this all the time. I would say what this judge did, but I'd be very clear because I knew what the reason for the appeal would be, and it was a very sensitive case. But if we send it back because we say, hey, it's a reversible error, what's going to happen on remand? You get close to the bottom of the guidelines, correct?
Correct.
And now the ceiling's back on. It's a de novo proceeding. Do you really want to reverse something and give that 25 years?
Well, Your Honor, I believe if.
I mean, you'll just do the right thing, regardless of consequences.
I understand, Your Honor.
I just don't, do you really trust all the trial judges in the world that you randomly get the trial judge who would have the right hat for this case? Take a chance. Okay.
Well, Your Honor, in talking to my client, yes, and I truly believe if his mental health issues, which are severe and started in childhood sexual trauma, were put before the court, there would be a much more arguable reason for the court to grant a motion for downward departure, and I think that's how the second. It's the first issue ties into the second issue, because in the first issue, the judge does bring up the battery two separate times.
Yeah,
I'm sorry.
It's for me not to read the record with respect to that as what the judge's concern was there is finding that he had violated the probation and committed new offenses. And I didn't really, I'm not as persuaded that I can see there's any ambiguity with why the court was talking about that in terms of considering uncharged conduct with sentencing. And if anything, I mean, I think the record weighs against that. I mean, the state was asking for 20 years, right?
That is correct, Your Honor.
And the court sentenced him to less than that.
That is correct.
So it seemed like the court was not, if anything, the inference would be that the court is not taking that uncharged conduct.
Well, that is a fair reading, Your Honor, and I concede that. However, the trial court did say, quote, even though the state doesn't have to file the charge, the state doesn't have to convict you of the charge, it's still sufficient. And then he went on to say right before imposing sentence, even though the state didn't file the charge, there's an allegation that there's a battery that occurred, and you have several prior batteries in your history, and this is a crime of violence. And then he imposed sentence. And this court in Wyrick has specifically said, quote, where the record may reasonably be read to suggest that the defendant's sentence was the result, at least in part, of the consideration of an impermissible sentencing factor, such as uncharged conduct.
sorry,
Okay.
your argument was very good, and I see where you're coming from, but just personally, I'm having struggling with that aspect of your argument.
I'm gonna tell you, you've got about 30 seconds left, and I want to give you a tip for something I want to ask you on.
Yes.
Rebuttal.
Yes, Your Honor.
Which is, I want you to square what you just said, or help me figure out how to square what you just said with the third district's opinion in Jackson.
Yes.
I'll give you half a minute to tie it up, and unless you want to go into your rebuttal, it's your time.
I'll just do it in rebuttal, Your Honor. Thank you.
Good morning, Your Honors. Annalise Walker on behalf of the state of Florida, the appellee in this case. May it please the court. Your Honors, the trial court did not err in considering Mr. Bogen's new law violation of battery when revoking his probation and sentencing him. The record that we have is clear that Mr. Bogen, when he admitted to violating his probation, he admitted to this new law violation of battery. The affidavit of violation of probation contains 3 new law violations: the possession of cocaine, the possession of drug paraphernalia, and the battery. Then Mr. Bogen entered a plea admitting
But the
to.
battery charge had been dropped, so how did he enter a plea to that?
Well, Your Honor, that is not in the record. And also he is admitting the new law violation of battery. He's not admitting to the separate charge of battery in Manatee County. So he's just admitting to these new law violations. Also, the plea form in which he admitted the new law violation, it simply states that he admitted to violating his probation. It does not state that I'm admitting to some new law violations in the battery, not others. It just wholesale states that he admitted to violating his
The
probation.
battery wasn't charged. It's uncharged conduct, correct?
Well, I disagree with the premise that it's uncharged conduct because in violations of probation, the new law violation does not have to be charged and it does not have to be convicted.
For a violation of probation, yes.
Yes, Your Honor.
Which seems to be the court's concern, but the argument is whether or not it can be considered with respect to sentencing.
I think so, Your Honor, because it is also a violation of probation. He got points on it on the score sheet, on his criminal punishment score sheet. And also when considering whether to revoke probation and sentence the appellant, the trial judge must consider the totality of the circumstances and whether the appellant is amenable to treatment and whether he is or whether he needs to be sentenced or not. So I think that the trial court was fully within its bounds to consider the new violation of battery when revoking his probation and sentencing him. And also, lest there be any confusion about what he was admitting in the plea form, in the court's disposition order, it references the affidavit and it states that the court finds that the defendant willfully and substantially violated the following conditions of probation as set forth in the affidavit, and it attached the affidavit containing the new law violation of battery. So I don't think there was what the record that we have here. There's no confusion as to what he was admitting to or not admitting to regarding the violation of probation and the new law violations. And whether if he was admitting to some conditions of probation that he violated, not others, that would have been present on the plea form and that would have been clear in the disposition order. But that's not what we have here. And I'll remind the court that it is appellant's duty to supply a complete and full record for the court's review. But the record that we have here simply does not support his arguments.
Was there anything in the state attorney's statement to the judge in closing arguments, let's say, that summarized the judge's position on the first reason for departure, whether it was a legal ground to depart or not, that unambiguously eliminated any doubt that the judge didn't think there was a down departure, but if he did, then it wasn't appropriate for this gentleman?
Well, I don't believe the state attorney gave any closing argument, but the transcript the state contends is very clear that the judge was not going to depart from the statute. And moving to issue 2, for your question, I'll remind the court that there was no motion for downward departure, either orally or written. And the trial court, out of an abundance of caution, interpreting the argument that Mr. Bogen's counsel presented, it looked at the downward departure statute out of an abundance of caution. It looked at the factors and said, I'm looking at section 921.0026, which is the mitigating factors. and stated that I don't see a reason to depart. So this is a plain language bank step one analysis. The court is speaking to Mr. Bogen, saying I'm looking at the statute and I don't see a legal reason
I
to
mean,
depart.
basically what you're saying is that then they got a fair shake, whether you agree or disagree with the result, they got a fair shake. No one's entitled to a perfect trial, but you're entitled to a fair trial, and you're saying that's what happened here,
Yes, Your Honor. I think
or sentencing.
yes, and I think the trial judge did a very thorough job considering there was no actual motion for downward departure. The trial judge was covering all its bases and it thoroughly analyzed under Banks. And also for step two, the court went through Mr. Bogen's criminal history and it went through the first violation of probation and went through the second violation of probation. And it stated that it was all out of chances to give. That's record page 207. And then it stated that I don't see a reason to depart and I'm not going to. So I think regardless of the battery, this was, the court stated that this was a substance abuse issue. There was no competent substantial evidence before the trial court that there was an independent mental disorder that required treatment. And so I think that's why the trial court, when it looked at the statute section, said, I don't see a reason to depart because there's no evidence before it upon which it could depart. And so if I move back to issue one,
No.
no? Okay. So, Your Honor, regarding issue two,
Did you just ask if you could go back to issue one?
yes, Your Honor.
You can argue an issue one.
Oh,
I think he misunderstood your question.
oh.
Look, you have any facts you have questions about?
Oh, no, I was asking if I can move back to issue one because I know we jumped.
Oh,
issue
no,
here.
I'm sorry.
Okay, whatever the court,
I apologize if I said-
whatever the court requires, that's what I will do. Okay, so for issue one, I believe the record is abundantly clear that he admitted to all three new law violations. And as I was stating, it is Mr. Bogen's duty as the appellant to supply record before this court. And what we have simply does not support what he's arguing on appeal. And so I would ask this court to affirm on the first issue. And I guess wrapping up on issue two, I believe one of the panel members discussed Getsky and that it is harmless error under Getsky if the trial court unequivocally states that it's not going to depart from the guidelines regardless of any error or confusion on bank step one. And that is exactly what we have here. I don't concede error. I believe that the trial court did thoroughly analyze the downward departure under bank step one and regarded admittedly plain language bank step one. But under Getsky, any error is harmless because the trial court unequivocally stated it was not going to depart. It stated that it was all out of chances to give. This was Mr. Bogen's second violation of probation on a similar drug offense because the first violation he had he tested positive for substances and then now he's caught again with illegal substances. And so the court was referencing that when it's all out of chances to give, and that's record page 207. So I think the record is very clear that the court was not going to depart. So under Getsky, any error is harmless. And if this court has no further questions, I will rely on the state's brief. Thank you.
Thank you.
You have your full 5 minutes.
Thank you, Your Honor. And I'm going to end with Jackson, Your Honor, just to let you know that you specifically asked me to address that. I want to address two other very quick points. The state just mentioned that the judge did all that it could do by just referencing the statute. Mr. Bogen's position is once the judge references the statute, this court has said this, that it is incumbent upon the court to then go through the two-step process. And there was Defense Exhibit 1, which the judge said he had reviewed. There was evidence in the record to support a mental health issue. He had PTSD, suicidal, he had tried to hang himself in the record. So that was Exhibit 1. But once the judge said, I've looked at the statute and I don't see a reason to depart, it was incumbent upon the judge, not trial counsel, for the judge to go through step 1, is there a legal reason to depart? And then step 2, if I have the power, whether I should.
Well, I have a question. Let's assume the judge is still on step 1, did it slowly and correctly. Is that a judgment call? There's a reason to depart or not? Because the facts could have been interpreted, well, I don't think that's enough. You say it is enough, but suppose the judge took the contrary view.
Well, in the record, there was nothing to dispute that Mr. Bogen suffered.
I understand, but
Right.
normally that's going to be a credibility finding, goes to the weight, not the admissibility. Judge rules against your client.
Right.
Call it or anything you can do on that. We certainly can't correct the judgment call.
We just don't know why he wasn't finding a reason.
I got it. I understand.
And then very briefly about admitting to the battery conduct, the change of plea form just says admitting to VOP sentencing set. And even the state and the judge inquired very clearly on the record, the battery was no filed, correct? And the state is correct that there's nothing in the record to say that he actually did admit to that, whether the judge at the end.
If we get too big on that.
Yes.
What's the standard of proof on the conviction on the VOP? Is it just a preponderance?
Yes, Your Honor.
Okay, that's pretty low standard, not reasonable doubt.
That's correct, Your
So
Honor.
considering something that the guy did, it's probably fair game. Even if he did, even if he didn't consider, he could have considered it. Why would that not be fair game? You don't need to require
Right.
prove that he got convicted of something that he did. It was bad conduct, putting him in law violation, maybe he wasn't, maybe the state shouldn't discuss it, but they did.
Mhm.
Why is that reversible error?
Well, my point is, first of all, Your Honor, as to the state, he didn't admit to it. He didn't admit to the conduct of battery.
Right at the threshold of Jackson, you've got about 2.5.
Yes, Your Honor.
And when Jackson speaks,
And
it's pretty direct to the argument that you're making right now. That's really what you like.
yes, and let me quote from Jackson. I think this is what you're referring to, Your Honor, where it says, where the probation has been revoked based on charged and uncharged conduct, the revocation order must be reversed where it is unclear whether the lower court would have revoked probation and imposed the same sentence absent the uncharged conduct. Is that essentially?
Well, and
For your honors.
the court went through an analysis where the trial court had commented on the uncharged offense, and it doesn't seem a whole lot different to me than the big picture of what we have in this case. And that's why I wanted to ask you to address it, because it, concludes that in that instance, it was clear that the trial court would have revoked his probation and imposed the same sentence. And it's hard for me to distinguish the analysis and resolution in this case from what is before us and what you're asking us to do.
Well-
So that's what I wanted to get your.
Well, the importance in this case, it's not as if the trial court mentioned 2 times right before imposing sentencing, you had cocaine in your pocket. He mentioned there is a battery. And I know it wasn't uncharged, but there's an allegation of a battery. He mentioned specifically the battery 2 times before imposing sentence. He did not mention the possession of the controlled substance. So our position is it is unclear because that's what it looked like the court was focusing on. If you read the record, whether he would have imposed the same sentence. That is how I would distinguish Jackson, Your Honor, if that answers your question.
Yeah, 30 seconds left. Thank you.
I thank you for your time. I'm honored to be here on the last second DCA in this building and look forward to seeing you all in St. Petersburg.
Good luck, Barry.
Thank you.
Stay tuned.
Thank you. Nice job.
Thank you.